Inheritance and wills remain one of the most overlooked areas in India's digital reform journey, and this neglect has profound consequences for fairness, equity, and economic justice. When Prime Minister Narendra Modi emphasizes the need for the next wave of reforms, he often points to the transformative power of digital platforms like the Jan Dhan, Aadhaar, and Mobile Trinity. These initiatives have revolutionized access to social welfare in ways few countries have matched. But here's where it gets controversial. Despite these advances, the domain of inheritance and wills has largely been left untouched, even though India's changing demographics and expanding middle class make reform in this area more urgent than ever. Shockingly, only a tiny fraction of Indians actually write wills, and among those who do, the practice is heavily concentrated in major metropolitan areas, leaving vast rural and remote populations without this crucial legal safeguard. Even when wills exist, the system is riddled with problems like forgery, multiple conflicting wills, and lengthy court battles that drain time and resources. The root of the problem lies in limited access to legal expertise in smaller towns and villages. Traditional wills require handwritten signatures and physical witnesses, which not only complicates the process, but also restricts scalability and adoption. This is where electronic wills, or e-wills, come into play, offering a promising solution that could cut through bureaucratic red tape and make the process faster, more secure, and more accessible. Electronic wills provide a streamlined alternative to paper-based documents. They tackle issues like physical storage risks, limited accessibility, and the potential for tampering. With e-wills, testators and witnesses can complete the entire process online, removing geographical barriers and reducing the time and costs associated with in-person meetings. This digital approach also promises to ease the burden on courts by minimizing disputes over authenticity, thanks to non-reputable authentication methods and auditable digital trails. Importantly, it can bridge the gap in legal infrastructure that currently exists in rural and remote areas. Globally, various forms of electronic wills are already in use, and India is beginning to catch up. For example, Chapter 4 of Uttarakhand's Uniform Civil Code Rules 2025 introduces procedures for registering and updating wills online via web or mobile platforms. This allows testators to register their wills or codicils digitally, simplifying the process and reducing reliance on physical paperwork. They can also revoke or reinstate previously registered wills or declare a particular version as their final will through this online system, enhancing clarity and accessibility. The rules even incorporate technology by enabling registration through multiple channels, including web portals, mobile apps, document uploads, and video statements. While this is a significant step forward, it stops short of fully embracing digital wills, with features like electronic signatures or blockchain-based authentication, technologies that could further enhance security and trust. Looking beyond India, the United States offers an interesting model with the Uniform Electronic Wills Act, UEWA. This law validates electronically stored wills, permits remote witnessing, and includes a harmless error clause but allows courts to accept wills that don't perfectly meet execution requirements, as long as they clearly represent the testator's intent. Since its introduction in 2019, the UEWA has been adopted by 9 states, including Colorado, North Dakota, Utah, the US Virgin Islands, and Washington. Advocates believe this law will modernize estate planning, encourage more people to draft wills, and resolve issues related to handwritten wills by providing a consistent legal framework. Canada has also made strides in this area. British Columbia and Saskatchewan have enacted legislation recognizing electronic wills as valid testamentary instruments, with British Columbia's Bill 21 updating its wills. Estates and Succession Act in 2021 to include digital wills, remote virtual witnessing, digital storage, and the ability to revoke or update wills electronically. For India, any effective solution must enable will creation through digital channels, especially mobile devices, and support vernacular languages to ensure inclusivity. It should leverage technology to guarantee non-repudiable authentication, employing Aadhaar-based OTP or e-sign methods for both the test data and witnesses, coupled with video testimony to add an extra layer of verification. However, introducing electronic wills in India will require careful legal reforms. Amendments will be needed in several key laws, including the Bharatiya Sakshya Adhiniyam, 2023, the Indian Succession Act, 1925, the Information Technology Act, 2000, the Hindu Succession Act, 1956, and the Registration Act, 1908. As India accelerates its digital transformation across sectors, recognizing electronic wills could revolutionize estate planning. It would encourage more people to formalize their succession plans, addressing the current gaps in accessibility and legal recognition of digital documents. Most of us know someone, widows, children, or other dependents, who have been unfairly denied their rightful inheritance because no will existed or because the will was never enforced. This is the part most people miss: the human cost of outdated legal processes. Implementing these reforms would deliver the fullest justice to citizens, ensuring that inheritance rights are protected and that the wealth passed down shapes a fairer, more equitable future for all. The author, a former banker, is now an entrepreneur, investor, and strategy coach.